My name is William Lawrence, and I want to welcome you to our April installment of our ongoing advertising group webinar series. And today we'll be talking about legal trends and pitfalls in sports advertising. We thought that this was probably a good time to begin discussing these subjects with the World Cup coming up in 2025 and 2026 in the United States and North America, and with the Olympics coming to LA in 2028. We figured that some of you all might be asking some burning questions concerning how you might get your brands and companies involved in capitalizing and commercializing some of these events and pushing your products and affiliation with some of these major world sporting events. And we wanted to go ahead and sort of begin to give you some insight and potentially some cautions on doing so and how to hopefully do so properly, and course, encourage you to consult with proper counsel as you continue to do it. So as I say, my name is William Lawrence. I am a counsel in the advertising group and intellectual property litigation group here at Venable. And I have with me today my colleague, Ellis McKennie, who is also an associate in the advertising group, but also an associate in the sports law group. And so I'll let him get this particular subject kicked off. Go ahead, take it away, Ellis.
Yeah, thanks everyone for coming. We really excited to do this type of webinar. Myself as a college athlete, and William has plenty personal and familiar connections to college athletics and athletics generally. Anytime you get a intersection of your professional life and your personal life in a topic like this, it makes the webinar more exciting, made the research more exciting, and it's extremely topical. March Madness just ended. We got the NFL draft tonight, and like we've talked about, we have these two major world events coming to the US and coming to North America in the coming years. So it was exciting to do this research. I'm really excited to do this webinar, and I'm glad we got the opportunity to do this. And so here at Venable, we've got a budding sports law group that is getting off the ground, and we're really trying to begin to ramp up the work that we're doing and the work for clients in the sports space. And so we had some of our data analysts put together a list of the growing trends in sports and trends to watch, especially in the legal landscape of sports. So we pulled three of those. That was league and competition growth, college sports transformation, and digital takeover. And then from those, we picked the specifics of them to present on today. But leagues and competition growth is just the way that sports and the way that professional sports particularly have begun to grow and have continued to boom in terms of revenue, in terms of television, in terms of streaming, and that creating that many more advertising opportunities for everyone involved. And then that leads into FIFA and the Olympics bringing their products, bringing their tournaments, and bringing all of their viewers to the United States in the coming years. And we think that's going to be an important issue to discuss. Next, we talk about the college sports transformation and the rise of NIL and the way that has impacted both collegiate athletics as well as women's athletics and women's sports at a college level. We dive deeper into that and the advertising issues along with it. And then finally, we'll touch briefly on the digital takeover. In 2025, everything can, on our phones or on a screen, but that includes things like online gambling and esports, two big industries that have risen, in this digital age and have become places where advertising is not only utilized, but it is almost necessary, and it is one of the better ways and better mediums to reach certain audiences. So we take a little dive into that as well.
Now, before we jump completely into all of the sports specific topics, over the course of giving these presentations, I've tried to begin or at least integrate basic principles to sort of keep in mind whenever you're dealing with any advertising. This isn't sports specific, but these are just sort of good rules of the road to kind of consider when you're beginning to consider a new campaign or some sort of new advertising affiliation or some sort of new testimonial or influencer purpose. You really want to kind of think about these general principles. Of course, the panacea for all of this is to consult with counsel. But these are good things to kind of begin to consider like preliminarily as you're sort of beginning to think about how you want to approach a particular advertising event. First is truth in advertising. Sounds so simple. Tell the truth. Don't lie. Don't be misleading. However, it gets more complicated when you start thinking about whether or not you are being completely accurate in your representations, whether or not potentially you need substantiation for certain claims that will require testing or some other proof of kind of what you're claiming, whether or not you actually need to know whether something that you are claiming is actually true, as opposed to being just ambivalent to whether or not it is completely accurate. That leads us, of course, into false and misleading advertising, which also is more complicated than it sounds because it takes into account the real context of the full advertisement, whether or not there are necessary implications or implied falsity within sort of whatever statement that you're actually making, such that it may mislead a reasonable customer who, although otherwise the statement would be true, will look at it and say, this is what I thought it was, and whether or not you've sort of met the standard to protect yourself if you're making those sorts of statements. The FTC guides concerning endorsement and testimonials. I mean, if you guys are using customers to promote your products, or using celebrity endorsements, which you see as the next thing, and or using influencers generally on social media, I'm hoping that you're very familiar with these guides, which is really the resource that you want to look to when you're looking to avoid pitfalls with the FTC on those sorts of issues. And that takes us to the next one, which is disclosure requirements, which is kind of half the battle when it comes to endorsements. You know, you kind of have to make sure that it's very, very clear that one way or the other, your the promotion from your customer, your influencer, your celebrity endorser is actually compensated. Because if somehow it is misleading to customers concerning whether or not this is an unbiased endorsement, then you're going to get in some trouble. And all of that kind of wraps into the ultimate responsibility of the advertiser, of the brand, of the person promoting the product, actually benefiting from the advertising. I mean, you'll use a lot of third parties in your advertising endeavors. You'll use advertising agencies, you'll use artists, you'll use influencers, you'll use celebrities, but the ultimate buck usually stops with the person whose brand they are promoting. And you are responsible for making sure that they meet all of these different requirements as you go about your advertising campaigns. And finally, as I said, I also work on the intellectual property side. And I know from years of experience that these issues are very integrated. Most of the time when we're bringing claims or defending claims on behalf of our client, it is a crossover between, you know, potential trademark infringement or potential copyright infringement, or sometimes even a potential patent infringement, and how the product is advertised and whether it was false or misleading. So those are very important things. Make sure that the collateral that you're using, the trademarks and copyrights, or whatever you may be using within your advertisement, make sure you do your due diligence and that you are approved to use it and you're not using it in unimproved or misleading ways.
Yeah, I think this is just an important slide for us to start with in any of our advertising webinars. A lot of these webinars get into specific areas of advertising, but then if you really thought about them, you really look into any of the specific regulations, they're reiterating all of these principles. So it's really important just to remember these principles once we get into some of the guidelines or requirements that the specific sports related issues have. So like I said, we'll start with FIFA. So FIFA is bringing two massive events to the United States and to North America in the coming years. So in 2025, FIFA is bringing the Club World Cup to the United States. This is a new-ish event for FIFA. FIFA has been running a Club World Cup at a small scale, but this is their first attempt to make it a much bigger event, to make it almost like its Nations World Cup. In terms of popularity, in terms of number of teams. And so FIFA has already agreed to a $1 billion broadcast agreement with a UK streaming company to host this event. And the event's being held in the United States, where it will feature 32 of the best soccer teams from around the world. This is an event that I like to think of it as FIFA testing the US market, or kind of testing the waters and prepping us for the 2026 World Cup, which it hopes is going to be a massive success. And so they are bringing these teams with massive stars. I saw that even Inter Miami and Lionel Messi is going to be competing in this event, even though they may not have competitively qualified. They are also coming. That kind of shows FIFA's commitment, though, to making sure this event has enough eyeballs on it. And so in 2026, the World Cup is coming to North America, and specifically to the United States. And many of our cities around the country. So in 2022, the World Cup final garnered 1.5 billion global viewers, and that dwarfed the size of our Super Bowl. So what we think about as the biggest event in American sports doesn't even compare to what the World Cup final is going to bring. And so us hosting the World Cup final here in the United States is going to bring a global market with millions and millions of new viewers and eyeballs and advertising opportunities to the United States. So we have to make sure that we are prepared from an advertising perspective to tackle some of the issues that may come with FIFA marketing and advertising. And this is the biggest World Cup ever. They have expanded to 48 teams, 1,200 players, and 104 matches. So that's 48 teams, meaning 48 countries, meaning 48 markets, right? That is just the ever-growing size of FIFA and what it is bringing in the summer of 2026, and the amount of opportunities that people are going to have to connect with certain markets and certain consumers.
Yeah, and that's exciting. I mean, I heard that it was coming in 2026, and I'm looking already to see what DC games I might be able to go to, whether it's going to come to a place near us. And I'm sure your companies are thinking about this. I know brands are thinking about this. I know our clients are thinking about this. How can we capitalize on all of these eyes? I mean, bigger than the Super Bowl, and you know what the advertisements at the Super Bowl look like. What do we have to do to get participate? And the first answer that we would give is you got to follow the rules. And FIFA actually has its own advertising guidelines. Now, the interesting thing about FIFA's advertising guidelines, much like the FTC guidelines, although those kind of have much more of a, I think, direct impact on what US law is, these guidelines don't actually have any legal effect in and of themselves. So FIFA gives these guidelines, gives these rules of the road essentially to give anyone who wants to participate in advertising or somehow participate in, talking about the event, what they can do to not run afoul from FIFA's opinion concerning what would be an infringement of their IP in going about that advertising. And so what we have here are just a couple of excerpts from that guidance, just to give you a general idea of FIFA's approach and philosophy behind how it views its intellectual property. And so if you read with me, you'll see that FIFA says that the protection of FIFA's commercial rights, including the official intellectual property, is crucial for staging the tournament. And FIFA asks that non-affiliated entities and individuals respect FIFA's rights and conduct their activities without commercially associating with the tournament. And this is specific examples of the guidance. Official intellectual property may not be used together with or in proximity to a company logo or commercial reference, such as brought to you by or presented by or sponsored by. Relatively straightforward or simple. We'll talk a little bit about, what it means to be an affiliated individual or affiliated entity that might allow you to use some of these phrases and what you would potentially have to do to go about that. But long story short, if you know you're not affiliated, if you know you don't have those sorts of licenses, if you don't know you don't have those sorts of approvals, don't pretend to. Um, you know, then the next one is the use of official intellectual property by fans without commercial intent is generally accepted. However, excessive use of official intellectual property may create the impression of an association and therefore should be avoided. This is a very interesting one because what FIFA seems to be doing in its approach is to carve out a space for its fans to, be fans, to be excited about the events, to post about the events, to, really sort of get into these huge events. And this is part of where FIFA gets its revenue. But, to the extent that it's clear that they're not trying to capitalize on what is protected intellectual property of FIFA. The next one is similar. Editorial and descriptive use of the event is permissible as long as the use does not create a risk of confusion that service is in any way connected to the tournament. Once again, newspapers, local companies, different people who are going to be vendors at events, they're not saying that you can't say that potentially you'll actually be at one of these events or just sort of, give some sort of advertisement if you're a stadium or something like that, that the event is happening there, editorial or descriptive. But once again, it's a line between using that to associate yourself somehow with FIFA. And finally, generic football or country related in-store decorations do not create an unauthorized association or generally accepted. Once again, you can imagine that the home team store and the home team vendors and other people are going to want to be able to continue to sell jerseys for that team as they probably do year round. And simply because they're participating in the World Cup that year, that won't be disallowed. But once again, it's going to always be judged on whether or not there seems to be an implication that that is now officially associated with FIFA or any of its intellectual property.
Yeah, I think before we move forward, the second one here is very interesting to me. The intellectual property by fans. And in 2025 and then in 2026, I can envision a scenario where an influencer of some kind, someone on social media saying, come along as I, go to 40 games in 40 days, right? Or come along while, this brand sponsors me to go to 40 games in 40 days of the FIFA World Cup. And while FIFA doesn't want to restrict people from being fans, they don't want to restrict people from going. If you want to buy a ticket to every game and say you bought a ticket to every game, feel free. But there's a limit to that, right? There's a limit to the use of the IP. And there's a line between using the IP and then using it excessively, right? And then using it for a commercial benefit as well.
I think that's the point. I mean, FIFA is not turning down sort of organic advertising. They
Right.
don't want people to, once again, not be fans and not be super excited about this and not do some of those crazy stunts that I'm sure some of the influencers will do, doing 10 backflips at every game, whatever they're going to do, whatever gimmick they come up with. And arguably, that is the type of stunt and the type of advertising that is going to actually probably continue to bring followers to their page, follower to their social media page, so that they can, monetize that and increase their own capital. I think really what the FIFA is focused on here is how much of their official intellectual property is used in that expression. I mean, they're really focused on the fact, and I think you'll talk about this later, they have a lot of different intellectual property that goes along with these events. They've trademarked it, they protected it, and they're going to use it for their own benefit. And so to the extent you begin to cross a line where it's clear you're using that intellectual property to commercialize your own brands or to commercialize your own products, I think that's where it's going to get a little sticky.
Right.
Which brings us to kind of their enforcement approach. And I kind of think of this as the don't start nothing, won't be nothing approach. They kind of say like our approach to brand protection focuses on education and guidance rather than on enforcement by means of legal threats and sanctions. We prefer to engage in direct personal contact to bring infringing situations to an end by speaking to the business in question, explaining why the specific situation is problematic, and seeking their cooperation to resolve the issue. And I think this, once again, kind of goes to our point that it seems like the philosophy here is that FIFA kind of wants to encourage people organically being fans of this event. It is a huge sporting event. Soccer fans, football fans, soccer fans are crazy.
Yep.
And they want to see some of that fervor in their social media posts and sort of they want to see that. But, the point is they kind of have given these guidelines and they want people to sort of work within those guidelines specifically to ensure that the advertisements aren't infringing on their intellectual property.
Yep. And so we've spoken about what FIFA intends to protect in terms of their intellectual property and the way they look at it. But they do offer the opportunity to be authorized. We speak a lot about the unauthorized use, but let's talk about the authorized use for a minute. So FIFA offers different partnership levels for brands and businesses to cooperate with FIFA. And so there's the FIFA partners, which is the highest level. These grant global commercial rights to all FIFA competitions. These are your big commercial brands, Adidas, Coca-Cola, Hyundai, the ones that you will see, this game presented by Coca-Cola, right? Those are the big brands, and they have these global rights over all FIFA competitions. Then there are FIFA World Cup sponsors. Plus, these sponsors have global commercial rights in relation to the men's national team competitions. So they're very specific here. They kind of narrow it down a little bit each level we go down. They've got rights to men's national team competitions, not just the World Cup, the lead up to it and the different continental competitions and things like that FIFA puts on. These types of sponsors are obviously a little bit more long-standing than the ones below. Then you have FIFA World Cup sponsors, the normal, not plus, normal. They have global commercial rights only in relation to the tournament. So that's where we start to get very specific. They have global rights only to the FIFA World Cup, and that likely renews every World Cup. And that allows new and growing brands who would like to market globally just for that specific event. Then you have FIFA World Cup tournament supporters. So these are regional rights. These are rights that maybe a U.S. specific company wants for this specific tournament. And that allows you not to have to be an Adidas to get a sponsor to be authorized by FIFA, right? That allows some of our smaller companies, some people who may not have never been in the soccer industry before or have tried to target that market, may seek this type of support or this type of affiliation in order to use FIFA IP just likely in the United States for this tournament. There are also host committee, host city supporters, and host city donors. This would be for the United States in 2026 and 2025, just local, smaller brands. And then there are two types of licenses that FIFA uses for their branding: branded official licenses and branded unofficial licenses. So for the branded official license products, these are allowed to bear the official IP of FIFA and the licensee marks. So this indicates a close association with the tournament. This allows you to have your brand right next to the FIFA brand or on the same product as the FIFA brand or something of that nature. Whereas they also have the opportunity for unbranded official licenses. So these are products that are only going to bear the IP of FIFA, and they're not going to contain the marks of the licensee. So they may not create the same association, but they allow the brand or the business to deal in FIFA products, right? It allows them to put FIFA products either for sale or allows them to put FIFA products in their marketing materials and things like that, where it's not going to create the same association, but you do have rights to use the FIFA IP.
So Ellis, I mean, maybe break that down in terms of the unbranded official licensee just a little bit more. I mean, is this something that I guess vendors of just actual sort of gear might use? Is it something that like sort of local stores who want to sort of brand their products with? Who
Right.
who would want to use sort of the unbranded official?
Right. So I would think of it as the branded official license where you can use both brands. It's going to be a sportswear company, any of those big sportswear companies that are going to make a t-shirt with their brand on it that says has all the FIFA IP on the front. That's where you're going to need the branded, where you can have both of our logos on the same t-shirt. Now, if there's a mom and pop sportswear shop who wants to sell that t-shirt, they may be looking for an unbranded official license, or to be able to market that they're selling that t-shirt. Or if you're just a vendor in front of the stadium who's going to set up, a month-long permanent shop there and sell FIFA merchandise, you're going to be looking for something like an unbranded official license. So so FIFA just takes on the general stance that advertising or branding cannot give the overall look and feel of association with the official tournament without being one of their affiliates. So I just want to look at some of the examples. These examples are provided by FIFA in their guidance. So feel free, you can go and check out their guidance and check out they have a long list of examples and images like this. This is one, like we were talking about earlier, of editorial and descriptive. So on the left is one that FIFA does not take issue with, Football World Championship quiz. Do we know what we're all talking about if we're taking this in the summer of 2026? Probably. But is it infringing on any FIFA IP? Is it using any FIFA trademarks, any FIFA marks? It's not. Whereas on the right, that looks like FIFA, the entity, is sponsoring this quiz and is in relationship with the brand or with the app. But I think that's important because you look at some of the marks that FIFA has decided to trademark and establish, they can be very broad. So it's important to understand which marks and which slogans are even trademarked by FIFA. For example, the 2026 World Cup has the slogan, "We are 26." It's kind of tough to, that's it's a bit generic, but at the same time, you may have a marketing department who thinks they're going to come up with that and use it for the FIFA World Cup, and you may end up with a letter from FIFA. Or if you use it in conjunction with a city that's hosting a FIFA game, a World Cup game. They also have got stuff like, they've been have it in Spanish as well, Copa Mundial, and French. They've got World Cup 26 and things like that. So I really would recommend going to these guidelines and looking at the complete list of what they have trademarked and what they believe to be protected IP, because some may be a little bit more generic than you think they could be. So here's an example. I think this is a great example of the difference between a branded license and an unbranded license. So on the left, that would be approved for an unbranded license, right? That's just using the FIFA IP. There's no brand of yours. That's in an editorial set. It looks like they may be writing about the event of some kind. Whereas on the right, presented by Sample Limited, right? That is where FIFA will find issue if you're not a properly authorized brand or business with FIFA. First of all, just the presented by, right? They laid that out very clear. That is a phrase that they're looking for. And I also just think the proximity, like you won't be able to get, if you remove presented by there and just put your brand right next to it, I still think FIFA may find an issue there as well, just because of the proximity and the association with the event and the event's IP.
And I find those examples useful. I mean, really go and look at the guidelines. It's the same as sort of the FTC guidelines. Like, they kind of try to lay out different scenarios where you're going to encounter these issues. And so just going back to what we were talking about earlier, that social media influencer who wants to sort of maybe, increase his following by going to all of the sort of World Cup games in 2026, he can probably accomplish whatever his title or headline of that is going to be by calling it "Watch me attend the Soccer World Championship all summer," whatever he wants to say. That doesn't use any FIFA collateral. That doesn't suggest some sort of association with FIFA or any of their trademarks, as far as we know, although they should definitely check what the trademarks are, because as you said, they could be extensive, but a way to accomplish that without actually running afoul of the guidelines.
Yeah, absolutely. And I think like we've talked about throughout, FIFA is in the business of getting people to watch their games and to go to their games and to talk about it and to buy gear associated with it. So I think that's reflected in their enforcement statement, where they just want people to respect their IP and talk about the tournament correctly and be able to, gain the correct type of popularity and eyes and vision on the tournament. So we pulled a couple of examples of this, a little bit more extended use of FIFA's enforcement issues and some terms or phrase or advertising they found issue with. So in 2010, in the lead up to the World Cup in South Africa, FIFA sent a cease and desist letter to the airline Kalula. And we can look on the right and see what that advertisement was. Kalula was getting a little cheeky here, right? They thought the unofficial national carrier of the you-know-what. I think we all know what you-know-what meant. I think everyone who saw this ad knew what you-know-what meant, and that's the stance FIFA took, was that everyone knows that you're talking about our event. You're trying to create an unauthorized association. So please stop, right? 2014, in the lead up to the World Cup in Brazil, FIFA took a similar action against Brazilian travel company Decolar's tagline, Viva Mundial. This one's a little bit more, it's close. It's a close call, right? You're just talking about the world, right? Like, let's go the world, But in Brazil, in 2014, right around the time of the World Cup, I have a feeling FIFA was on the right track in thinking this was trying to create an unauthorized association. And so, while never directly mentioning the tournament or the tournament's IP or FIFA's IP, FIFA took issue with these ads because they created an unauthorized association.
And so those case examples kind of lead into the next point a little bit concerning the FIFA guidance. I mean, as a US host, you have to imagine that a lot of these advertising issues in 2026 are going to occur under US law. And so, although the guidance says, certain references must be generic, there must be generic country related images, terminology that does not incorporate FIFA IP, I think we can see there are some questions, and intelligent minds may disagree on what qualifies as generic and potentially what qualifies as actually properly incorporating the IP. And there might even be some challenges to whether or not their IP is too generic.
Yeah.
And that is all going to be things that are going to be handled under US law. And so there are going to be some interesting questions. I mean, of course, I think our advice is always to stick as closely to the guidelines as you can. As you saw, like when you try to push the envelope, oftentimes that is what puts you on FIFA's radar. And if you want to stay off the radar, get a branded license. It makes sense. If you want to advertise your brand with it, don't beat around the bush. See if it's actually valuable enough to your brand to get a branded license. Avoid the direct association. Don't try to skirt the boundaries. Just, do it the right way and use generic advertising. But once again, that could become a sticky question, which is why we always sort of say, be cautious and be careful. But the reason we say that is because, your business isn't litigating these issues unless you happen to be a lawyer on the phone who's also kind of, just tuning in to get an update. Your business is something else. Your business is selling a product or a service, and you're trying to use these events as sort of a profit creating center. Don't let that enthusiasm, lead yourself into creating a cost, which would be sort of litigation and having to kind of handle these issues up against what, as we know, is a very large, powerful organization. Even though FIFA, wants to play nice, as you saw from these cases, they are willing to protect their intellectual property.
Yeah, and I think it's an interesting case, and especially for us legal nerds out there, we'll really like to see how some of this presents itself, right? We've seen for years the Super Bowl and the NFL has protected the Super Bowl IP, but there have been times where they've allowed companies to use the big game or something like that and obviously create an association. So we'll see how U.S. courts deal with that. I also think it's interesting to think about our stadium rights. In Qatar in 2022, a lot of their stadiums were built for the World Cup, right? And so there weren't really branding or corporate issues with that. In the United States, we are going to just be using our current infrastructure. We're going to be using NFL stadiums for the most part that already have big corporate sponsors, like we see AT&T Stadium there in Dallas. And so will those companies have to come to agreements with FIFA? Will FIFA take issue with an aerial shot like this if they don't have an agreement with AT&T? Those are interesting, just like little case studies that we're going to have to pay attention to, I think, in the next year. And so since we know you have your attention, we will give out the CLE code. That is Trends 2025, Trends 2025, and we will move on. So similar to the World Cup and to FIFA, the Olympic Games are a massive worldwide event that bring new viewers and new markets and put their eyeballs on the United States. So in 2028, we will be hosting the Olympic Games in Los Angeles. And this now brings the world to the US. This brings all the countries who send athletes and all of the media and broadcasting and all the buzz around the World Cup for the summer to the United States and to Los Angeles. So that's an exciting thing. In 2024, the Olympics averaged 30 million viewers across all platforms, which was an 82% increase from Tokyo. So we can only guess what the increase, especially among US watchers, will be in 2028 when it is here in the United States. I can imagine we will send the most athletes we've ever sent to an Olympics. With it being home, we will have we'll have the interest, a lot of countries catching up. It's going to be an interesting Olympic Games, and so that's going to bring all the more viewers and all the world market's attention to the United States.
So I'm starting to feel like Ellis is just setting me up to be a buzzkill. So that's all very exciting. A lot more eyes on the United States, potential for you to advertise your brands and affiliation with this, huge world event. But much like FIFA, the Olympic organization, the Olympic Charter, exists and it has its own rules. And one of the most important rules when it comes to advertising is Rule 40, which is one of their bylaws. And I mean, essentially, it is very similar to how FIFA handles things. It says only approved sponsors, which we'll kind of more specifically talk about that also, can use Olympic symbols, can use the mascot, can use host city, can use the collateral that they have, intellectual property rights in. Rule 40 is a little bit different because while the FIFA rules, as you saw, really focus a lot on the actual intellectual property and the commercial association, Rule 40 has a timing aspect to it. It focused more so on this idea of a games period, a period around the Olympic Games where certain advertisements that before may have been considered generic enough to not warrant some sort of violation if it's in proximity and there's some sort of uptick in how much you're doing it and what you're doing, it might end up being, as you can see from our example here, there's some clear associations where you're actually using the Olympic ring versus not. But depending on what athlete is in this picture and whether or not they're participating in the Olympic Games and, how much you decide to push that the closer you get to the Olympic Games, you could also have some problems with Rule 40 in the IOC. And so that's really something to think. So, for example, in Paris, the game period was from July 18th to August 13th. And during this period, non-partners could only run campaigns if they had permission of the relevant athletes, if there were no Olympic properties are used in the ad, if it respects the policies of the IOC relating to activities incompatible with the Olympic movement, and the ad was considered general advertising. Now, one of the interesting quirks of Rule 40 is also that Rule 40, as part of the Olympic Charter, really regulates the participants in the Olympic Games. So this is a little different than the general FIFA guidelines that is meant to regulate everyone, and really without sort of, court intervention, they don't have any necessary teeth. This one has teeth as it pertains to the participants in the Olympic athletes. So it's kind of a different approach in terms of regulation. It's sort of like, well, if these rules aren't followed vis-a-vis the participant, then we'll find a way to potentially punish the participant, which of course, vis-a-vis would probably get to the brand that is sponsoring them. And we'll get a little bit more into how those dynamics might break down too.
All right, so we'll break down a little bit about the specific terms in some of these rules. So Olympic partners, they are brands or companies that have sponsorship or official merchandise licensing contracts with the IOC or the local governing bodies. And so Olympic partners are granted specific rights. They are permitted to use participant images and Olympic properties, subject only to obtaining participants' consent, terms of the partner's contract with the IOC, and respecting the supplementary guidelines for Olympic partners. So that's pretty standard, pretty straightforward. If you have a contract with the Olympics, contract with a participant, and that's likely how you're going to proceed with your advertising. Now, non-Olympic partners are permitted to use participant images. If you have a deal or a sponsorship deal with a certain athlete that you'd like to promote, that is still permitted use, but only when they obtain participants' consent, they are subject to the policy of the IOC, They do not use any Olympic properties, and the images are used in generic advertising. What's that mean? Well, the Olympics tells us what the generic advertising is. They give 3 requirements. 1, where the only connection to the games is the fact that the advertising uses the participant's image. 2, which has been in the market for at least 90 days before the games period. I think that is very key and one that sets this apart from the FIFA rules and maybe other advertising basic principles that we think about. And 3, which is run consistently and not materially escalated during the games period. So that's what we talked about, how the Olympic rules are more timing based than anything else, less on the IP side than FIFA is. And I found it interesting that in terms of advertising, they consider congratulatory marketing not to be generic advertising. That is because if you are congratulating them for winning gold, it's intrinsically connected to the games. And so they find that to be run afoul of the generic advertising rules and to be not permitted if you aren't a sponsor. And so, like we talked about, they implement a games period. And the games period runs from the opening of the Olympic Village to 2 days after the closing ceremony. That's a little bit extended from, opening ceremony to close ceremony, or first event to last event. But that's kind of the time around the games that they want to be protected. And so in 2028, that's not yet finalized, but we do know the games themselves will run from July 14th until July 30th.
I just find it, you kind of touched on this, but just to reemphasize, it's just a very interesting dynamic that you have with the Olympic advertising, where your advertisement in any other time of the year may be just fine.
Right.
But in the run up to the Olympic Games, depending on how you do it and depending on how you place it, it could become infringing.
Right.
Which is really something that I think you should consider, especially as you consider like the endorsers that you may, make contracts with, the athletes that are participating. You don't want to sort of lose out on them because you start pushing an ad that you otherwise would have had and otherwise can push at the wrong time. So it's just a very interesting, different set of considerations.
And I think the IOC recognizes their place in athletics, where it is a 2 weeks every 4 years that you get every eye on these Olympic sports. And so what they've done is they've created a model that gives you notice ahead of time that during this period, we are on you. We are paying attention. We are watching your marketing, because there are, 3 years and 50 weeks other than this where, we won't be in the market. We won't be in the public eye. So we'd appreciate if you didn't take advantage of our IP during these 2 weeks. Whereas FIFA is a daily institution. It runs soccer and football globally and runs events and leagues year round. So that is something that FIFA's more focused on IP compared to the Olympics focus on this time period. Kind of makes sense, right? So here's an example that we pulled, again, right from the IOC guidelines. You can go check these out. What appear to be carbon copy advertisements, right? But the one on the left is permitted as generic advertising, as there's no connection with the Olympic Games other than the use of the Olympian. The brand has demonstrated that the campaign has been in the market before April 18th. So this is something where you can work with the IOC, right? If you're going to put out an advertisement to say, hey, we've got proof that this ran 90 days before the beginning of the event. The athlete's achievements are listed factually and not more prominently than other achievements. So that's an interesting one, right? Where Olympic silver medalist is certainly on that advertisement. And in some cases, you may think oh, that could be something that they take issue with. However, they said, no, it doesn't stand out. It's factual. It's it's in his resume of wins. That does not run afoul of any issues. They want you to say that he's an Olympic champion. That is a good thing to hear, but it's not like you're capitalizing on the Olympics. And there's no Olympic properties used. Whereas on the right, we clearly see Road to Paris, and that is enough to make an unauthorized association. You're trying to use the notoriety from the Olympics coming up to gain, more attention to your brand and to your athlete. And so here's a I think a great example of what the Olympics are looking to protect against. So as we see here, it's Kevin Durant and his advertisement with Prime Hydration. And so they faced issues in 2024. Kevin Durant, NBA star, maybe Mr. USA basketball, has competed in 4 or 5 Olympic games now, winning gold medals. Prime Hydration used him in their ad using Olympic colors, used trademarks like the Olympics, the Olympian, which, as we were just talking about, are true. These are facts. But the timing of the ad right before the Olympic Games and right before the Rule 40 blackout period were clearly ran afoul of Rule 40 issues. And so, there are additional points to make, right? There are also points about those who do it the right way. Coca-Cola, the official beverage sponsor of the Olympics, may take issue with this type of ad. And so Prime heard these issues and removed the advertising before the case could proceed. But this is an example of, especially on the ad that we're looking at on the right, there actually may not be any IP on there. But if that's the day before Team USA's first game, I think we all understand the association they're looking to make.
And another probably much less well-known issue probably is, there was in the Winter Olympics, there was a snowboarder, Julia Marino, who was forced to withdraw from the 2022 Big Air competition due to her snowboard. Now, Rule 40 does allow exceptions for equipment that bears branding of traditional sports brands. So I'm not aware of all of the different brands of snowboards, but I'm pretty confident that Prada has never made snowboards probably before then. So the whole idea was that this wasn't just an incidental sort of showing of a sportswear brand on a necessary piece of equipment on Olympian. This was clearly a branding placement on the bottom of the board. And so because of that, the IOC determined that Prada did not primarily deal in sporting goods, and therefore her board was an advertisement in violation of Rule 40. Now, what is kind of scary about this, especially when you're thinking about the Prime situation and you see our, USA basketball team's performance in the last Olympics, that last advertisement, the penalty, hypothetically would have fallen on Kevin Durant.
Yes.
So he could have been excluded potentially from some of the Olympic Games because Prime was not following Rule 40 as they should, because here, this particular Olympian was excluded from at least some of the events. So it's very important to consider kind of how they operate. You spend all of this money getting, the celebrity endorser who's going to participate in the Olympics, who's going to put your brand on a huge world stage. You probably invested and spent a fair amount of money on it. If you don't comply with these rules, and they just get eliminated from particular events or somehow get, disqualified, then all of a sudden, depending on how your contract is written, a lot of that money may be down the drain. And that could be a big investment, especially for a smaller company or something like that. So, these rules do have teeth in kind of a different way than the FIFA rules that can kind of have some immediate consequences on the Olympian and the brand.
Yeah, and I think we also got to give the Olympics a bit of credit here as well. This exception to the rule that equipment that bears traditional sportswear brands is kind of meant to support the smaller athletes out there in the smaller nations who may not be able to get, a Nike sponsorship, who I'd imagine is a partner of the Olympics and you can wear their brand. They may have a smaller brand that funds their bobsled team, right? Like, who knows? But so the Olympics can carve out that exception. They understand that's not advertising. That's what they're using as a sportswear brand. But here's the opposite side of that, where, like you said, Prada is not making snowboards. I don't think that's the case. So what these rules are looking to prohibit is what's known as ambush marketing. By definition, it's prohibited marketing activities which try to take advantage of the huge interest and high profile of an event by creating a commercial association and or seeking promotional exposure without the authorization of the event organizer. And so that is really what these rules and guidelines are coming down to. They are trying to limit the number of unauthorized association that brands are making with their tournament. They've worked really hard. They've built these tournaments up. They understand the value of being associated with them, and they offer avenues to become associated with them. So they are really looking to protect themselves, their athletes, and their competition from these types of marketing efforts. And so there are three kinds of ambush marketing. There's ambush by association, which is what we were just talking about, the kind of most simple side, where you attempt to associate, and that may lead the public into thinking that you're actually allowed to associate, that you are an authorized user, that the Olympics do support whatever brand, product, service you are advertising. Then there's ambush by intrusion. This is gaining exposure to the events, targeting the audience in the stadium through broadcast media. And then finally, there's opportunistic ambush, capitalizing on newsworthy moments from an event to gain exposure because of that newsworthy moment, because of that period. And so at the top here, we see a classic example of ambush marketing. And so this is a picture of Neymar with a specific headphone brand. And FIFA had its own official headphone sponsor. And so in and around the stadium and in the locker room and on the field for warmups, you could not wear a headphone brand other than their official sponsor. So this brand, who is a sponsor of Neymar, thought it'd be, funny to say the game before the game. That's where you can wear our headphones. And that's a type of ambush marketing. That's trying to, without being an authorized sponsor, they're trying to gain, more notoriety and more value from the World Cup. And then the one on the bottom, I just thought was fun. That's one that we saw. It's ambush marketing. This is probably, if you really are a stickler for definitions, might not be ambush marketing, because I don't think this is prohibited marketing activity, but this is Smile, the movie that came out a few years ago. And I think all of us remember this kind young lady who was, in the crowd at all these events with this look on her face and the Smile t-shirt, and then getting in the background of broadcast to advertise. So this idea of ambush marketing is really what these events are trying to limit and really get a handle on. And so that leads us to our next topic. And so we're moving out of the world of these global events. I'm going to start talking about NCAA and the rise of women's sports. The business of college athletics is truly what it is now. The business of college athletics is booming. It is massive. The NCAA brought in $1.3 billion in revenue in 2024. Years ago, Jay Billis used to tweet every day anytime someone signed a new contract or one of these deals got signed and say, well, I guess there's just not enough money for the players. Pretty clear there's enough money. There's enough money to go around, and that is what we're seeing now. They had a $1 billion deal with CBS for March Madness. There was a $65 million deal with ESPN for all other NCAA championships. And these are even excluding the college football the college football playoffs, which is set aside from the NCAA. So it's not reflected in these numbers here, but that's a $7 billion contract with ESPN for the college football playoffs. So there's enough money to go around. And now, with the introduction of NIL, where student athletes are able to capitalize on their name, image, and likeness, and able to make money and get financial gain from being a college athlete, we are seeing some of these numbers that are being thrown around, and we're seeing the impact college athletes can have in marketing. As we see here on the right, Juju Watkins in a State Farm ad, right? These are the types of big organizations and big brands that are going to capitalize on NCAA student athletes. And that's, again, to mention that female athletes have had the ability to capitalize on their increased status and popularity as well through social media, through their play, through their just style to take advantage of it just as much as anyone else. And this has led to the increased notoriety of some female athletes.
And so we just kind of wanted to go over just briefly. This isn't technically an anti sort of trust seminar or anything like that. It's really advertising in sports, but I think it's always important to kind of remind people of how many issues often cross over with advertising. So everyone knows about sort of these Supreme Court cases that ultimately led to, compensation for college athletes and all of this crazy NIL money that's floating around and all of the effects that it's had on the way collegiate sports is played. But, this was really created by an antitrust case, in 2021 in a non-zero decision in Austin v. NCAA, the Supreme Court pretty much ruled that the NCAA's, definition of amateurism as meaning that they could not pay the players any amount of money over scholarships and educational expenses was anti-competitive. They were essentially stopping these players unfairly from participating in what has been for a long time a billion-dollar market. And they pretty much said, that is not okay. That is the definition of what is anti-competitive. And in 2024, this really sort of all came to a head with this settlement in House v. NCAA, where essentially the NCAA said, hey, we're going to settle these cases. We're going to agree to compensate former and current players for their sort of participation or any sort of, NIL usage that we've used in the past that we didn't pay them for. And right now they are trying to figure out rules concerning how they're going to continue to compensate players for their participation in college athletics. And so, that is kind of going on right now, which, as you've seen, the landscape of college sports has already changed drastically. Once the settlement comes through, we're going to continue to see changes, and it's going to continue to be a huge, huge growing advertising industry.
Yep. See, I was expecting, honestly, after I, submitted submitted these slides last week to have to come on here and say, well, the House settlement,
Right.
was approved on Monday, Tuesday, and now this is going through. But there's, yet another change. The judge has given them 14 days to come to a different agreement about phasing in roster limits, another element of the House settlement that doesn't have to do with NIL specifically. And so we're continue to see, and the NCAA has also now introduced proposed legislation on how it would implement the House settlement were it to become finalized in the coming days. So there's a lot of movement in this space that is going to continue to change. And so what does this mean? So just to start, we are not experts on NIL collectives, on the transfer portal, on recruiting, any of that. We are advertising attorneys, and we really have taken the look at this from what NIL honestly was supposed to be, was student athletes having the ability to use their status, their image, their voice to make profit and to be assets to brands or other institutions who may want to capitalize on that as well. And so myself I was a college football player at the University of Maryland pre-2021. And so we were not allowed to profit off our own name, image, and likeness. We were barely allowed to, take anything extra outside of our education and, the meals and transportation and clothes that they provided to us. I was telling William a story earlier. We were given specific advice. Don't get a ride from a booster because, an Uber does have a monetary value to it. So if they're removing that from you, then, they're providing, compensation that is illegal in front of the NCAA. But now, as, the amateur nature of college athletics changes, it's a completely different world. My sister is a current college basketball player at the University of Maryland, and her experience is entirely different. She's working with brands. She's getting contacted by agents. She's negotiating with the university, the team, the transfer portal, and the way that works creates completely different process in the offseason. It's incredibly different. But what student athletes are experiencing now is no different than what the rest of society has always had. If you were a trumpet player in the band, you are allowed to drop a mixtape and make money off of it and market it to, third parties. Now student athletes are allowed to use their image, use their social media following, use their presence to make money for themselves. And it was only fair and it makes sense. That's why I preface this with the, collective and transfer portal. That's crazy. I don't really, we're not here to talk about that. But the normal, publicity and name, image, and likeness stuff, it's something that we've needed and are happy that it's been implemented. And so what are the restrictions then on advertising? What hard NIL restrictions does the NCAA have? And the answer is not too many. The Alston case kind of came with very strict instructions on get rid of this now, not with what you need to do instead. So the NCAA got rid of their model. They implemented a few restrictions, which we're seeing now kind of turn into the Wild West in sorts, and we're hoping that'll get resolved soon. But currently, the NCAA has minimal restrictions. Players must follow their state laws that are in place. Once Alston was passed and once NIL was legalized, states began to pass their own laws. And so they must follow the laws of their state. Athletes should report NIL activities to their school and conferences as required. I think there are two big pieces of that guidance, should and as required, right? So those need to be reported based on your school, based on your conference and what they're asking for. But the last one is the most important. Allowing NIL did not create a pay-for-play model per se. It must be a quid pro quo arrangement if you sign a contract with an NCAA athlete. You must be paying them for something. They must be doing an advertisement, doing an appearance, or promoting your brand or in some way, form, or fashion. It can't just be, because you're on the team, we're going to pay you this. That may change, and that is changing after the House settlement and revenue sharing. But in terms of NIL payments, that is not how it can be. And so if you're still participating in the NIL market without being a university or without being involved in revenue sharing, you need to keep that in mind, that it can't just be handouts, right? They have to be doing something for you. And so as we talked about, 32 states have passed NIL laws, largely modeling the California Act, which we'll talk about. And these state laws can vary in scope and applicability. And so in 2019, California passed the Fair Pay to Play Act. You'll say, well, 2019, that's pre-2021, and you are correct. This, could be seen as, part of the wave shifting, California pushing the envelope a little bit. And so they made an effective date of 2023, and in between there, God willing, 2021 was when Alston was decided. And so it made it illegal for universities and colleges in California to deny student athletes the ability to profit from their name, image, and likeness. It allows collegiate athletes to hire agents and other representatives to help negotiate and secure commercial deals. And an interesting point as well that has been pointed out recently is that it also allows California colleges to directly enter into NIL deals with athletes and recruits. This is an element that, nationwide or in terms of the NCAA standpoint would only become allowed, would have only become allowed with the House settlement and recent NCAA legislation. And so here are a few examples that I thought were interesting, just the way, these NIL laws can be different. In Arizona, it prohibits athletes from entering into contracts that conflict with their team's current contracts. So that could differ based off what school. If you're making a decision between Arizona State and Arizona, and you're a big time football player who has a certain contract, you may pick one or the other based off of what your team has in place already. In Illinois, it prohibits NIL deals relating to, some of these, syntax type industries, gambling, sports betting, controlled substances, cannabis, or anything that could be considered inconsistent with the institution. And then I have to call out the Maryland NIL law, which I was glad to help get into law. It's named after my former teammate, Jordan McNair. And we put in that statute that it also must impose health and wellness requirements. Almost made it a requirement saying that if you want to offer NIL, you have to meet certain health and wellness standards as a university. And as we know now in 2025, if you want to be competitive at all, you're going to be offering NIL to student athletes.
And so this next slide is really just for shock value and to really kind of illustrate how huge this market has already become and continues to sort of grow. And these are just some of the top NIL valuations for certain players that I'm sure you have heard of, across collegiate sports. And this just kind of shows that this is a real thing as the settlement becomes closer to being finalized and things become more solidified. As with anything, certainty will yield probably just more of these types of deals and more advertising opportunities for your companies and your brands to sort of, use, to partner with these college athletes on different deals that are going to be sort of advantageous for both parties.
Yeah, I think that's important because I've been speaking a lot. This is a former college athlete. I think about it a lot from the athlete's point of view and how great this was for student athlete rights. But at the end of the day, if you're a business, you can find lots of value in these student athletes. Juju Watkins is probably the third most recognizable female basketball player in the world right now. And she's still in college and still at the University of Southern California. And so she's the type of brand ambassador that if you're looking to break into that market or into that demographic, she's going to be someone that you're going to want to partner with. As well as Arch Manning, the quarterback for Texas. He's, the quintessential high NIL earner. He's got a legacy name with Manning. He goes to the University of Texas, the biggest athletic institution in the country. And he plays quarterback in the SEC, right? Like he's the type of guy that big brands like Red Bull and others are going to want to make a face of their brand. And they're going to capitalize on those where they, and especially when some of these may relate better than, a professional athlete or, some type of celebrity. These student athletes are very relatable and very good sources for advertising that businesses can take advantage of.
And so we just wanted to cover quickly with the time that we have left. We've talked a lot about more classical sporting events, the Olympics, FIFA, college sports, from point of sort of basketball, football, that sort of thing. But we can't forget that in the last 5 to 10 years, esports has absolutely exploded and sports betting has absolutely exploded. So, in 2018, the federal ban on sports betting was repealed. And now all of a sudden, what used to be something that happened in the dark corners of casinos in Las Vegas and other places is now kind of easily accessible in many, many states, depending on sort of your particular state laws, in the palm of your hand, on your phone, online, which has made sports betting over the last, 5-6 years really, really explode as an industry. And of course, sort of esports itself, a long time ago crested $1 billion as, an industry, and now is up to 4.8 billion in 2025. And there you're sort of dealing with a whole sort of new realm of sports. I remember, years ago, I think Bronny James' first Sports Illustrated cover was actually with his, esports, it's the Counter-Strike team. And it's only continued to explode from there. But we just want to remind you, the rules are kind of the same, when it comes to esports, following FTC advertising guidance, being very, very careful, especially since, more so than even with classic sports, these events are happening in kind of alternative forums. I mean, you have sort of the Twitches of the world. A lot of YouTube influencers are big into this. And, the events are kind of happening digitally. And people begin to forget the same rules that apply, whether or not you're being pictured on Twitch or you're being pictured on ESPN. The same rules of the road that we discussed earlier apply. Right. Esports also, they have teams at the collegiate level. So all the things we're talking about, NIL and sort of the compensation for, NCAA sports will apply to esports as well. And more so than maybe even in traditional sports, which is kind of, usually watched and supervised, esports and kids is huge. I mean, kids have access to their phones and their video games, oftentimes without kind of direct supervision of parents, which raises all sorts of different concerns for companies and influencers and brands concerning how you actually approach media, which, is particularly subject to kids without parental supervision, which could be an entirely different presentation in and of itself. But we just couldn't kind of end the presentation without at least mentioning the fact that this is a major component that I think brands have been focusing on for years, and it's only just getting there.
Because I think at the end of the day, consumers are consumers and viewers are viewers, and whether or not the World Cup's going to have 1.5 billion people watch the final, if there's going to be 1 billion people turn into, like you said, the Counter-Strike final as well, that there are advertising opportunities for all involved. And so, yeah, we couldn't go without mentioning that. We're going to go ahead and speed through these just in the adherence of time restraints. But the sports industry is an ever-growing market for advertising, right? We showed the numbers. We showed the events that are coming to the United States, and we all understand the way that sports interact with society and the vast swatches of our society that watch sports and watch these different avenues. I think it's really exciting for something like the World Cup, and a sport that in the United States is kind of taken for granted. The world stage and with the world's most important sport is coming to our country and coming to our shores, and now has increased the market for American advertisers and American businesses to take advantage. And so I really urge businesses and companies to look into advertising in the sports world, but to make sure before you do that you understand the risks and the pitfalls that can come along with that. And go ahead, Will.
No, I was just going to say, and, we're not going to leave without reminding you one more time that, no matter what you do, we can give you resources, we can point you to the guidelines, but, when you're starting to apply U.S. law and you're starting to consider U.S. courts, you may be considering what a jury's going to do and the application of those laws. Once you kind of come up with your idea of what you kind of want to do in these advertising campaigns, it's always a good idea to run it by counsel. I mean, there is no substitute, no matter what sort of new tools might be available out there, than having someone who deals with these issues from day to day and who is expert in actually sort of applying the law and making sure that you're kind of protected from all angles, some of which you may not have even considered if you're familiar with the territory, to give you real confidence that you can go out there and if something happens, you'll also be able to defend yourselves. And that's what we're here to do, and what other competent counsel out there is also here to do.
Right. So just before running any sports ad, let's just remember, check sport or competition specific rules. Make sure you understand the differences among them. Then check specific state laws. Make sure that you're not running afoul of state NIL laws, of state gambling laws, of states esports disclosures, of things of that nature. And especially now where a lot of states are starting to come up with their own mini FTC acts, where they're going to have their own definitions of what misleading advertising is, what truth in advertising means. So we need to make sure that we're on top of each of the state laws as well. Check FTC guidance for advertising, whether that's in the influencer and endorsement space, whether that's testimonials and reviews, or just their basic false or misleading advertising. And then finally, like William said, consult with counsel. Consulting with counsel on the front end is going to save you a lot of dollars on the back end,
If you'll go to the last slide with our contact info, we're definitely over time, and so we will take any questions that we found in the chat and try to follow up with you directly. But please feel free to email us, reach out to us, and ask us any sort of questions on this presentation, on other issues that you might find concerning as you go about your businesses.
Yep.
And thank you again for joining us.
And our end of webinar code for CLE is Trends 2025. Thanks so much, guys.